to that person doesn't say anything about what the court thinks about retroactivity. And the Michigan Court of Appeals agreed with that argument as well. So you got the Michigan Court of Appeals decision. It's the exact same result that the Florida Court of Appeals reached when presented with the exact same question. It's the exact same result that 2 federal courts of appeals have also reached involving that same question, the 11th and the 5th Circuits. So now, against that array of cases, you've got this decision by Judge O'Meara. And just to clarify, there are not 2 different federal court matters out there. There is one federal court matter. The case is in front of Judge O'Meara. This is Hill versus Governor Snyder. And there are 2 different orders that he issued. The first order is the one that we talked about a little earlier this morning with the one footnote where he essentially concludes that it's the fair thing to do to apply it retroactively. Compare that to the many, many pages of analysis in the Court of Appeals and in the various federal courts of appeals. He then issued a second order which says, and I'm going to apply this retroactively to everybody. And a couple things you need to understand about that. First, it's not even a class action case, and yet he applied it to everybody. Typically, you don't do that. It's a Section 1983 civil rights case, which the Supreme Court has clearly said you cannot use to alter the nature of a criminal sentence in the criminal justice system. There's an entirely separate process you have to do that. And he applied it to everybody after having previously said in the very same case that a great number of these convicted defendants are not eligible for relief because their claims are barred by the statute of limitations. So we would submit to the committee respectfully that once that opinion becomes final, and it's not yet because he's still trying to figure out how to reform our parole board as well, we will immediately appeal that. The Sixth Circuit will stay that, and the Sixth Circuit is going to reverse every single one of those rulings. They are not supported by the law in the same way that the Michigan Court of Appeals decision is in CARP. There's just no comparison between those 2. In response to some of the questions this morning, Senator Jones wanted to know if the defendants we're talking about here are all teenage murderers. And the answer to that is yes. We're not talking about petty crime. As Professor Thomas correctly stated, in the Graham case, the U.S. Supreme Court said you cannot give life without parole sentences for anything less than homicide. These are only homicide cases. Representative Heisey wanted to know about the Department of Justice intervening. No, they do not have the ability to control what we do in our state court system. In addition, they wouldn't do that on the merits because the federal government, like 3/4 of the states, have life without parole sentences for juveniles because everyone appreciates how heinous the nature of these crimes are. Representative Graves asked whether this Miller v. Alabama decision rendered Michigan's sentencing scheme unconstitutional. And the answer to that is absolutely not. Our life sentence is still valid. The only portion of it affects is the mandatory nature of no parole review. And as we've discussed, there's no reason to think that the U.S. Supreme Court will apply that retroactively. Representative Oakes asked about the Supreme Court being silent on this issue. As I referenced the opinion, those 2 sentences, they didn't cite Teague. They didn't say anything about retroactivity, but they gave us the Rosetta Stone, so to speak, to how to analyze this issue. It's not a categorical change in sentence. It is only a change in process. Representative Robinson asked about bad lawyers. I can tell you that in every single one of these cases, the bad lawyer issue was litigated in the Michigan courts with respect to ineffective assistance of counsel. It was litigated again on habeas, which is your opportunity to go to a federal court and say my attorney was so bad that I should get a second bite at the apple. All of those things were rejected. And then on the murder recidivism point, I agree with you that the recidivism rate for murderers is lower. But there's a reason for that, because for the most part, we don't let murderers out of prison. And if we do it when they're 70 or 80 years old and they're not likely to go out and commit another murder. But if you look at recidivism as a whole, what we do know, and this is well established in recent surveys, that 2/3 of released criminals go on to commit another crime, and 50% of them end up back in prison within 3 years after their release. And so, respectfully, Representative Robinson, those are the kinds of statistics that you need to be thinking about when you're thinking about someone who has taken somebody's life. And the last point that I would leave you with, and then I'm happy to answer any questions that you might have, has to do with this retroactivity trigger and possibly waiting. What the Attorney General has proposed is a trigger so that in the present day, Miller v. Alabama in this state would not be applied retroactively. But if someday the U.S. Supreme Court holds that it should be retroactive, that you would immediately have the same system in place retroactively that you have prospectively. Well, what's the difference between having a trigger and just making it immediately retroactive? If you make it retroactive through legislation, then the victims' families and friends that you see here today and that were not able to be here today, but who have been affected by these murders, would be forced to come back into court at a Miller v. Alabama hearing and relive the death of their loved one all over again. And if the U.S. Supreme Court ultimately says Miller is not retroactive, as we believe that they will, then you've put all of those families and friends through that trauma for no legal reason. And you need to think very carefully about whether that's something that you want to do. If the Supreme Court ultimately says, yes, we do apply this retroactively, fine, then there's a trigger in place to take care of that. But that's a very, very onerous step if that's the one that you choose to take. And it's really, in effect, sentencing these families to a lifetime of having to revisit these things. Even in the parole system, let's say someone comes up for parole under the current legislation after 15 years, and it's denied. Well, that's almost worse, because then these victim family members and friends are resubmitted to this horror every 5 years for the rest of that person's life. So these are not small matters that we're talking about. One non-legal point that I also want to address, and that's the neuroscience. And I'm no neuroscience expert, and I'm sure you're going to hear a lot of testimony later on today about how teenagers are different. But as Jessica Cooper, the prosecutor from Oakland County, is going to testify, these issues about age and whether you can appreciate what you did are taken into consideration at the time of charging, whether you choose to charge someone for first-degree murder as an adult. We're not talking about stupid or risky behavior where, you know, your 40-year-old brother or your 17-year-old brother goes out and gets drunk and does something dumb. We're talking about rape, torture, skinning, burning people alive, really the most heinous type of crimes that you can possibly imagine. And that's why the legislature imposed life without parole sentences for these situations in the first place. There's no reason to ask either the parole board or judges in cases that have long since been final to revisit this with the family members present. So I'm happy to answer any questions you have about any of those topics.
Thank you. I have a few for you. Do you think that Miller is, the Miller decision is more of a procedural matter than a substantive change?
I absolutely do. The Roper and Graham decisions that Professor Thomas mentioned are a good juxtaposition to that. When you say that in Roper, juveniles are not eligible for the death penalty, that changes the substance of the sentence that they can get. If in Graham they say for a non-homicide crime, they're not eligible for life without parole, again, you've categorically changed the nature of the sentence. But here, just as the Supreme Court said, and I'll read you that sentence again, our decision does not categorically bar a penalty. Instead, it mandates that a sentence follow a certain process. And I really don't think it could be much clearer than that.
If it is a process issue, then and I haven't read the full context of Teague, but if you look at it through the lens of Teague, if it's a process issue, then wouldn't fundamental fairness dictate that retroactivity be applied? How would you answer that?
Well, fundamental fairness isn't the test. The court has said because of our interest in finality and not relitigating criminal cases decades over and over again after they've finally been decided, that if it's a process rule, as this one clearly appears to be, they are only going to apply it retroactively if it's a watershed event. And again, they've never concluded that, since Teague, that any change in procedure was a watershed event. They have suggested, in a case that took place before Teague, an example of what a watershed event might look like, and that was when they first announced that every defendant had the right to have an attorney in court. And an important distinction between that kind of case and this one is that everyone gets an attorney affects every single case that goes through our criminal justice system. This applies to only a very small number of people in the justice system. And again, it just requires a hearing. It doesn't have anything to do with the final nature of their sentence. So under Teague, it's pretty clear. Now, if the U.S. Supreme Court wanted to abandon Teague in favor of a fairness test, you know, something more along the lines of what Judge O'Meara did in Hill, they can do that. But yeah, I can represent to you here that that's not going to happen. They're going to apply Teague.
What do you think the chances are, and crystal ball this one, of a certified question to the U.S. Supreme Court? I mean, we're not the only state that's wrestling with this right now.
As I've mentioned, there are 2 other circuits, the 5th and the 11th, that have reached the same result as the Michigan Court of Appeals. I think that eventually it's possible that this will get to the U.S. Supreme Court because this issue is present in so many states, and over time, as this percolates, there are bound to be some conflicting decisions on that. And at some point, the U.S. Supreme Court will step in and say, yes, we need to decide once and for all. But I don't think that's going to be for a couple of years. And in the meantime, you're just playing Russian roulette, so to speak, with the victim family members and friends. If you sentence them to going back to court and having Miller v. Alabama hearings, when someday the U.S. Supreme Court could say, no, we never meant that to be retroactive.
You've talked about, and the AG referenced a potential bill that might include a trigger clause that in the event the U.S. Supreme Court renders this retroactive, X, Y, and Z will have to be triggered in a particular bill. I haven't been at this job for more than 3 years, and I'm not familiar with any kind of bill or law that we've adopted recently that contains language like that. Is such a trigger clause even legal or constitutional in the state of Michigan?
Oh, sure it is, absolutely.
Give me an example.
I can't give you any specific examples. It's possible we might be able to provide you with those. But there's nothing unconstitutional about having the ramifications of a law change based on future events. So, for example, if the court strikes down this provision, well, here's a good example that's in almost every one of your bills. If a court strikes down this provision of the bill, we intend the rest of the bill to be severable, such that each of those provisions will still stand as though they were passed independently. That's a good example.
Well, that's a severability clause, which I think is a little different than implementing a policy or procedure based on a future legal court decision that we can only speculate on.
Right, but both of them are contingent on a future court decision. In one case, retroactivity. The other case, a portion of a law is invalidity. And there's probably others, too. The reason why it makes sense to have a trigger like that is because you don't want to be left in the situation where you have a vacuum, where let's say you act only prospectively, and then the U.S. Supreme Court comes down in 2 or 3 years and says, yes, we meant this to apply retroactively, and now you have no system in place for all those retroactive cases, and you have to have hearings and revisit this issue all over again. If you've already decided the policy going forward, it's a relatively simple matter to apply the same policy backward, but for the sake of victims and to respect the judicial process, to make it contingent on that U.S. Supreme Court ruling.
Okay, and if you can find something else other than a severability clause,
sure,
let me know over the next couple weeks. That'd be great. Representative Robinson.
Thank you. You mentioned Apprendi versus New Jersey?
Yes.
It's not, okay. I just want to know, I haven't read that in about 1.5 years. And I'm having a difficult time understanding how you can take that. I mean, I want to get clarified in my brain, okay? Just, you have to be patient with an old lady. Your basis, or that's Apprendi versus New Jersey, is the strength that you're given to your argument against retroactivity. Is that correct?
It's an example where sentences could change based on the fact that a jury rather than a judge decides the facts that might result in sentencing enhancements. And yet the federal courts of appeals have unanimously held that's a procedural change, not a categorically different substance of the sentence. And the U.S. Supreme Court has never saw fit to reverse that.
But isn't Miller versus Alabama a violation of the 8th Amendment, and Apprendi versus New York is a violation of the right to jury, the 6th Amendment, where a judge sentences someone to prison where the jury has not made a determination of guilt?
The important distinction under Teague is not which constitutional amendment is being invoked for the substantive right. The question is whether the U.S. Supreme Court decision categorically changes the nature of the sentence for which you're eligible, or whether it merely imposes a new process that did not exist before.
All right. I appreciate that. The
Sure.
other thing I want to ask you, in your review of the Ginther, of the issues on these three, you went through 323 young men's or young women's appeals. Is that what you said? And they all exhausted their ineffective assistance of counsel issues?
I can't tell you that every single one has, but the vast majority have. And what I can tell you from my experience is that ineffective assistance of counsel claims in the Michigan courts and even in the federal courts very, very rarely succeed. And if any one of these defendants had succeeded on that claim, then they wouldn't be sitting in jail with a final life without parole sentence.
Okay. Are you familiar with People versus